I am absolutely thrilled to have you here today because we're going to tackle one of the most fascinating, foundational tensions in all of human society. Seriously, it's a big one. We're looking at the very delicate, high-stakes balance between the state's massive authority to punish and your fundamental individual rights. It's essentially the ultimate tug-of-war, and today we're going to see exactly how the rules of this game are drawn. Okay, let's dive right into this. Have you ever actually stopped to think about what prevents the government from just waking up tomorrow and deciding that your perfectly normal, everyday activities are suddenly illegal? I mean, what keeps the state from using its immense power to just arbitrarily lock people up? It's a pretty terrifying reality to consider when you really sit with it. Because without boundaries, government power can be incredibly destructive. So, how exactly do we rein it in? All right, here's our roadmap for today. We'll start with the power to punish, then look at the constitutional shield, unpack due process, examine equal protection of laws, and finally, we'll ground all of this in a real-world case study, Garcia versus Drilon.
Section 1. The power to punish.
So, let's start at the foundation. What is criminal law? Well, it's the branch of law that defines crimes, treats of their nature, and provides for their punishment. Think of it as the ultimate rule book. It's the state basically drawing a hard line in the sand and saying, look, if you cross this, there are going to be consequences. But that begs the question, where does the state actually get the authority to draw that line and write this rule book in the first place? That authority comes from something legal scholars call police power. And no, this isn't just about police officers out on patrol. We're talking about the state's inherent, massive authority to define and punish crimes, lay down the rules of procedure, and ultimately guard the community's interests. It's a fundamental right of a sovereign nation to defend its society from harm. This power touches almost every single aspect of daily life, giving the state incredibly broad discretion to act for the public good. But, as you can probably imagine, unchecked discretion of that magnitude can very easily morph into tyranny.
And this brilliantly illustrates the concept. As the jurisprudence in U.S. versus Pablo notes, this right of prosecution and punishment actually belongs to the sovereign power by natural law. The state is instinctively charged by the common will of society to look after and defend the community. It's essentially a survival instinct for society as a whole. But, like any instinct, it needs to be tempered by reason and strict legal boundaries.
Which brings us to Section 2, the constitutional shield. To balance out that massive police power, we absolutely need a barrier. In the Philippines, that shield is found right at the very beginning of the Bill of Rights. Article 3, Section 1 of the 1987 Constitution is your personal anchor against government overreach. It famously declares, "No person shall be deprived of life, liberty, or property without due process of law, nor shall any person be denied the equal protection of the laws." This single, incredibly powerful sentence is the literal bedrock of all criminal defense. Now, that foundational sentence branches out into some ironclad limitations on the legislature. When enacting penal laws, the state's hands are tied in a few key ways. They cannot deprive you of life, liberty, or property without due process. They cannot deny equal protection. They are strictly forbidden from passing ex post facto laws, meaning they can't just suddenly pass a law today that penalizes an action you took yesterday when it was perfectly legal. They can't pass bills of attainder, which would be like the legislature directly punishing you without ever giving you a trial. And they absolutely cannot impose excessive fines or inflict cruel, degrading, or inhuman punishment. No way.
Section 3. Unpacking due process.
We hear the term due process constantly in the news, right? But what is its core purpose? Ultimately, the guarantee exists to prevent arbitrary governmental encroachment against the life, liberty, and property of individuals. Notice that word arbitrary. Due process is fundamentally an anti-arbitrariness rule. It ensures the government can never, ever just act on a whim. Now, due process actually operates on two distinct layers. First up, we have substantive due process. This looks at the law itself. Is it intrinsically valid and fair? The government has to have a legitimate, logical reason for interfering with your rights. Think of it as the what of the law. Second, we have procedural due process. This concerns the actual steps the government takes. It demands proper notice, a fair opportunity to be heard, and an impartial judge. This is the how. So if the what is a fair law banning a harmful behavior, the how is ensuring you actually get a fair trial before going to jail for it. Both the what and the how must be completely fair.
Section 4. Equal protection of laws.
So at its core, equal protection requires that all persons similarly situated should be treated alike. The law cannot give undue favor to some and unjustly discriminate against others who are in like circumstances. Simply put, if you and I are in the exact same situation, the law has to apply to us in the exact same way.
But here is a crucial legal truth. Equal protection does not forbid all classifications. The law actually groups people differently all the time. But for a classification to be constitutional, it has to pass a strict four-part test. 1. It must rest on substantial distinctions. We're talking real material differences here. 2. It must be germane, meaning highly relevant to the purpose of the law. 3. It cannot be limited to existing conditions only. And 4, it must apply equally to all members within that newly defined class. So true equality isn't just identical treatment across the board. It's justified treatment based on real differences.
Let's move to Section 5 and see how this builds. Case study, Garcia versus Drilon.
You know, abstract rules are great, but seeing them applied is where the real learning happens. Let's look at the landmark case, Garcia versus Drilon, decided on June 25, 2013. This case centered on Republic Act No. 9262, the Anti-Violence Against Women and Their Children Act. The petitioner in this case argued that the law violated the Equal Protection Clause because it specifically targets violence against women. The core argument was basically, wait, shouldn't the law against violence protect men equally? Isn't this unconstitutional gender discrimination?
This challenge perfectly pits a very common misconception right up against true legal doctrine. The mistaken belief is that equal protection always requires strictly identical, across-the-board treatment for everyone, no exceptions. But the true constitutional doctrine is that a law can validly classify and protect specific groups, just as long as it meets those 4 strict requisites we just talked about. So, the Supreme Court systematically applied that 4-part checklist and ultimately upheld the law. They found RA 9262 was a valid response to documented systemic violence against women. The court recognized substantial, highly relevant distinctions between genders in this specific context. The classification was entirely germane to the law's protective purpose, since it was rooted in historical unequal power relations and real gender-based vulnerabilities. Because it passed all the requisites of valid classification, the law wasn't arbitrary discrimination. It was targeted, necessary protection. So the crucial point in criminal law here is this. Penal legislation absolutely remains subject to due process and equal protection. The state's power is always on a constitutional leash. However, constitutional equality does not demand identical treatment of materially different classes. The law can, and frankly must, recognize real-world distinctions to provide genuine justice. We've seen today how the massive power of the state is checked by the Constitution, and how equal protection is this living, breathing concept that adapts to societal realities. And it leaves us with a pretty provocative thought to end on. If equality doesn't always mean treating everyone exactly the same, what other laws might validly classify you differently tomorrow? How might the state use valid classification to address the next big societal challenge? Keep that active tension in mind the next time you see a new law being passed. Thank you so much for joining me for this explainer, and as always, keep questioning the world around you.